Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Indian Evidence Act, we were discussing chapter 10, which is all about examination of witness, covered between section 135 to 166. And in that series, we have already covered 3 videos, and in our last class, we have discussed section 137 and 138. And here comes a bonus video on section 137 and 138 as I committed in my last class. That is why I have named this as video 3A. Here we are going to understand the objects, rules and the legalities as to examination in chief and cross-examination. You will have 2 beautiful slides. I am not getting in detail because every single word there I have used is a content, like we have already discussed or we are going to discuss all of them. So I am quickly taking you through what are the objects, rules and legalities. And yes, of course, we have 2 case laws here. Not taking much of your time. Let's get into the first slide. Let us start the discussion with objects, rules and legalities of examination in chief, because that comes first in the order. Now, if we have to see the objects of examination in chief, I have listed 6 important objects. Remember, these are not the only 6 objects. I have brought 6 very important objects of examination in chief. The first one is to depose the facts related to the case. Now, the examination in chief, the first object is to bring all the facts related to the case. So that's the first object, and to collect all material facts. Here, the examination in chief should ensure that all the material facts were brought into picture. It also helps to understand the case. That is the third object. And the fourth object is to remember all facts. The examination in chief should ensure that all the facts were collected, all the facts were remembered. That is the very important object. And the fifth one is to prepare witness to withstand the cross-examination. And sixth one is the continuation, that cross-examination tries to contradict the evidence, and to avoid such scenarios, one has to do a right examination in chief. Now, if examination in chief is not done in a right way, in that case the witness cannot withstand the cross-examination, and that will not suffice the requirement for that particular party. So that way it plays a very important role, and that's one of the foremost objective of this particular aspect. Moving on to rules, I have brought 7 important rules. Again, I am repeating, these are not the only 7 rules. There are multiple rules available. I have brought them into 7 important rules. And the first one is, they must be relevant, it must be brief, and it must be direct. When examination in chief done, all the facts that are discussed should be relevant to the case. It must be brief as much as possible, and they need to be direct. The second one is, a witness here only gives evidence of facts within his knowledge and recollection. You cannot bring in anything else. It should be within his knowledge and whatever he has recollected. The third one, the answer must be upon a point of fact as opposed to the point of law. That is very important requirement. And the fourth one, no leading questions. This is a very important requirement. Here in examination in chief, there is no provision or opportunity for leading questions, except for the exceptions given under hostile witness, or if there is court permission, or it is an undisputed matter or just an introductory part. In that case, leading questions are allowed. But as a principle, you need to remember that there are no opportunity for leading questions when examination in chief done. When I say hostile witness exception, it is discussed under section 154, which I will brief in my next slide. But for now, 5th, 6th and 7th rules are no improper questioning. Judge can also ask questions, and there are no hearsay or opinion related questions. Now, these are the 7 important rules when it comes to examination in chief. The last part that I am discussing here are the legalities of examination in chief. Now, the first and foremost requirement here is, while doing examination in chief, one has to ask all the questions possible. Now, they will be cross-examined, and in cross examination, if there are any new relevant facts came into picture, that can of course be re-examined. But prima facie, all the questions related to relevant facts need to be asked during examination in chief. That is the first and foremost requirement. Secondly, all those questions need to be relevant. The third point that I have brought here is a very important and interesting point. Sometimes an advocate may ask irrelevant and inadmissible questions, but before asking them, he has to promise to the court that by asking such irrelevant and inadmissible questions, he is reaching to a relevant fact. If he promises that to the court, and if court agrees, in that case irrelevant or inadmissible questions can be asked while doing examination in chief. The fourth point that I am discussing is mostly on what not to do. Now, he or she should not be asked if questions or but questions or suppose or hearsay or to make an opinion or to make a hypothesis. All of these should not be done while doing examination in chief. Of course, if the witness is an expert, you may ask such witness to do some hypothesis with the permission of the court, but that is also not allowed in most of the cases. So while doing examination in chief, if questions, but questions, suppose or hearsay or to make an opinion or a hypothesis is not allowed or appreciated. Then comes the questions needs to be on the facts. It should be an evidence to the fact. That is very important, and all the questions should be limited to the knowledge and recollection of the witness. That is very important legal aspect that one need to remember. And the last one is no leading questions allowed during examination in chief. As I said, there are exceptions, but they are very limited. So these are the few very important legalities during examination in chief. Then comes cross-examination, and here I have discussed the objects and rules related to cross-examination. The first and foremost question is how important is cross-examination, and to understand this particular importance we need to refer a statement made by John Henry Wigmore. He says cross-examination is beyond any doubt the greatest legal engine ever invented for the discovery of the truth. This is the importance of cross-examination. With the skill of cross-examination, one can discover the truth. That is what John Henry Wigmore says. Two important objects of cross-examination is to find out whether facts are tainted, and the second one is to prepare its line of defense. That means the adverse party will prepare its line of defense along with doing cross-examination. These are the two major objects, and this is mostly connected to the accuracy of the witness, credibility of the witness, what interest the witness has by giving such witness, what is the character of the witness, what was the health status of the witness, what is the veracity or the truthfulness of the witness, and the advocate can filter what are the truths and what are the statement which are lied by the witness. All of that can be done. He can also detect and help the court to understand the realities of the case. He can also expose the intention of the witness. Cross-examination also helps to understand the inclination or the truthfulness, the bias, or to what extent the memory of the witness is true, and what is the lifestyle of the witness or what is happening in the life of the witness, whether he is emotionally connected to the case. All of that can be understood, and the advocate can also expose the witness. He can screen, he can understand and expose the motive, he can understand and expose whether the witness is prejudiced. He can also give the description of what exactly the client or the witness is trying to give, and he can also expose the background of the witness. All of that can be done with cross-examination. Whatever word I have put in here. All of them are very, very important. Unfortunately, I cannot get into them individually one by one and explain all of them because it takes a lot of time. But these are very, very important aspects that one need to keep in his or her mind while doing cross-examination. All of that can be done. Coming to the rules, I have 9 important rules, and the first one is questions on relevant fact only here also. Just like examination in chief, during cross examination also questions can be asked on relevant fact. But the only continuation that you need to remember is if some questions not asked during examination in chief and during cross examination, if the adverse party want to ask question on those relevant facts, definitely those questions on relevant facts can be asked. That is a very important provision that we need to remember. And on those cross examination, re-examination can be done. That is one another aspect we need to remember. That is the continuation. Coming to the second point, during examination in chief, leading questions are not allowed except for few exceptions, whereas while doing cross examination, leading questions are allowed. This is a very, very, very important aspect one need to remember. Now, what are leading questions? That we will understand while discussing section 141 of Indian Evidence Act. The third point is there are no opportunity for indecent or vulgar questioning. That is one another important aspect, same as examination in chief. And just like examination in chief, here also judge can ask questions. The fifth one is here while doing cross examinations, question related to the conduct or the character of the witness can be asked. The sixth one is every witness should be allowed to do cross examination. That we also have case law. I will explain while explaining case law. And the seventh one is cross examination by the party which itself is invited the witness is allowed in case of hostile witness as under section 154. I am not getting into detail. We will discuss while discussing section 154. But remember, if the witness becomes hostile witness, in that case, the first party which has called the witness can do the cross examination. That is a very important aspect that we need to observe while reading the 7th point. The 8th point I have already discussed while discussing point number 1. Here it is not necessary that one can cross only those questions which are being asked during examination in chief. The new questions on relevant facts are allowed while doing cross examination. That is 8th point. And the last one is if there are written statements which are made by witness, they can be crossed again. That is very important aspect you need to remember. These are the 9 important rules. Before concluding the session and handing over it to Nishan, we have 2 important case laws. I am not getting into detail of those case laws because we have already seen these 2 case laws while discussing in my last video. They are Sharadama versus Kenchama, where it was very clearly said that it is only a witness who is examined in chief who can be cross-examined. That means one has to follow the order. First, there should be examination in chief and then there will be cross-examination and not otherwise. And in the case law of Banwari Lal versus State, it was held that a witness shall be examined means not only that he shall be examined in chief, but also that he should be permitted to be cross-examined and re-examined. One will get an opportunity to do examination in chief and the process will not end there. Once the examination in chief completed, there will be cross-examination, and cross-examination is the heart of any case. This is as rightly said by John Henry Wigmore. Beyond any doubt, the greatest legal engine ever invented for the discovery of the truth. But the risk here is if the advocate is not performing his skills rightly, then he is putting his or her client into risk. That is a very important aspect every legal practitioner need to keep in his or her mind.
The happiness of your life depends on the quality of thoughts. So always have good thoughts. With that, I am concluding this session. Please Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye bye.